The debate on euthanasia has reignited in the country once again. This time after a woman from Bengaluru filed a plea in the Delhi High Court to stop her friend from travelling to Switzerland for euthanasia. When a 40-year-old man from Noida, suffering from a debilitating mental condition, made plans to travel to Switzerland for euthanasia, one of his family friends recently petitioned Delhi High Court to stop him. Today in this video, we take a quick look at what exactly euthanasia is and what are the provisions governing mercy killing in our country. The term euthanasia or mercy killing basically refers to the practice of ending the life of a patient to limit their suffering. The patient in question usually is construed to be terminally ill or to be experiencing great pain and suffering. The idea is to let a person choose death over life in order to end their miserable existence. Different types of euthanasia are practiced world over. The first one is active euthanasia, in which a patient is killed by active means, such as by injecting life-taking doses of drugs. The other one is passive euthanasia, in which medical life support systems such as ventilators, etc. are withdrawn. Passive euthanasia can be both voluntary and involuntary. When the consent from a patient is taken, it becomes voluntary, and in cases in which a patient is not in a condition to provide consent and the decision on their behalf is taken by some other person, then it becomes involuntary. In India, the term gained currency from the case of Aruna Shonbag, who was in a permanent vegetative state since 1973 till her death in 2015. She had remained in the state for 42 long years. In 2011, the Supreme Court of India gave the verdict on this particular case, and taking into account the viewpoints of both sides, the court had denied passive euthanasia to Aruna Shonbag. But for future cases, it had allowed passive euthanasia with certain guidelines. The court had also decided that in order to prevent misuse of this provision in the future, the power to determine the termination of a person's life would be subjected to High Court's approval following a due procedure. The court had laid down certain guidelines to be followed. Whenever any application will be filed in High Court for passive euthanasia, the Chief Justice of the High Court should constitute a bench of at least 2 judges deciding whether such termination should be granted or not. The bench, before laying out any judgment, should consider the opinion of a committee of 3 reputed doctors. These doctors will be nominated by the bench after discussing with appropriate medical practitioners. Along with appointing this committee, it would also be the duty of the court to issue a notice to the state, the relatives, kins and friends of the person in question, and to provide them a copy of the report made by the committee of doctors as soon as it is possible. And after hearing all the sides, the court should deliver the judgment. This procedure is to be followed in India everywhere until any legislation is passed on this subject. In short, active euthanasia is completely prohibited, but passive euthanasia can be granted. Furthermore, in 2018, Supreme Court passed another order in the case of Common Cause versus Union of India, in which right to die with dignity was again recognized and passive euthanasia was legalized. It was permitted to allow the withdrawal of the life support system of those who are terminally ill and are in lifelong coma. Along with this, the court had also provided the concept of living wills. But most importantly, this case is likely to throw up unprecedented questions of constitutional laws about right to life with dignity and right of choice, especially since the patient himself is mentally conscious and capable of taking the decision to travel for assisted euthanasia. We hope you liked this new video and these relevant information. Do like, share and subscribe to us for updates on more contemporary issues. Thank you for watching.